And so I assume there's some standard for making a determination as to whether the parent is fit.
Not really.
That's what I was worried about, that you say that, well, a fit parent can make the decision what's in the best interest of the child, but then that raises the question of what's a fit parent.
And I think that's a judicial determination. I mean, from my perspective, you would listen to evidence about what are the decisions the parent's been making? How have the parents been behaving? What have they done in and around the child since the child's birth to each other in a relationship? I mean, has that parent made poor decisions in the past that would make the judge determine that they're unfit? And on that topic, one of the other things that I struggle with, and I think we agree on some of the presumptions of that courts should stay out of the way of fit parents who are not doing anything that's harmful to their children, and their children are thriving and they're doing well. Last session, the legislature passed a bill that said if you've been terminated, you can come back and ask to have your kids back and basically be reinstated as a parent. And so these are parents, from my perspective as a judge, if I'm going to terminate someone's rights and I say to them, this means that I have determined that for the rest of your life, you can't parent this child. Because if I thought you could, I wouldn't terminate you. I would do some other arrangement and in order and see, how we go. Well, last session, the legislature said no, even if they've been terminated, as long as it's been an agency termination, if they want to come back within a 2-year period and say, I want to be parent again, that under certain circumstances, the courts have to allow them to make that request and then make a determination. And so we've already determined they're not fit. And we're still going to let them come in and say, okay, well, I've got my act together. Do parents get their acts together? Absolutely. But at some point, there's got to be some finality. And so I think that statute that went into effect last September has sort of turned the parental presumption issue on its head. We don't give them the presumption of being a parent, but we certainly let them come in the door and say, I'm a parent. Because at that point, they're strangers to the child. When you sever a parent-child relationship, you now have these parents who are like somebody that's never met this kid. But we're saying, because you used to be a parent, that in and of itself gives you standing to come in and say, okay, I'm ready to parent again. And I know I've really gotten off in the weeds on that one. But in terms of just talking about consistency in the code and the way we're going to talk about parents and presumptions in best interest, that certainly is a, whoa, where did that come from issue.
Right. So we shouldn't muddy the water by, and I don't know if there's lots of case law about making a determination about what a fit parent is. Is there any case law or something? I don't believe there's any statute.
I don't think there is either, and I think that also is a scary thing to try to legislate, and you gave the perfect example. I grew up in Houston, lived in Houston my whole life until I retired. I retired to Cold Spring, Texas, population less than 900. If a child in Cold Spring, Texas is walking to school half a mile, I'm going to say, well, okay. If you are in certain areas of Harris County and the testimony before the court is, this kid's got to walk to school half a mile every day, there's a different part of the hair on the back of my neck that's standing up in that, and all of that sort of goes into best interest. But that doesn't mean the parent in Cold Spring is not fit. It means under the circumstances as they existed, they made a really good decision with regard to the kid. Same decision in Harris County might not be a really good decision with regard to the child.
I feel like what's being lost in this conversation, though, is the fact that the fitness of a parent is a presumption that's required by constitutional law. Is there case law? Yes, there's Supreme Court jurisprudence that says you must, as a court, as a matter of constitutional law, presume that the parent is fit. And then you may overcome that presumption with compelling evidence that shows that for whatever reason, decisions that the parent made that are so out of the ordinary or puts that child in such a dangerous position that, okay, this parent's not making the decisions that a fit parent would make. But we can't lose sight of the fact that we have to start with the presumption that every parent enjoys under the Constitution, that they are presumed to be fit unless it can be proven otherwise.
I totally agree with him, and I just don't think that defining best interest will impact that. I completely agree with him that that's the presumption, and it's in a number of places in the family code.